Hi, good evening, everybody. Whoever is here, I hope you can all see my screens. I would really like this to be an interactive session. So, every time I ask a question, I would appreciate that you type a response in the chat box. Okay, great. Thank you, Saket. You can see my screen. Good evening, everyone. I'm Advocate Astha Garg, and I'll be your course instructor for this course titled Basics of Contract Drafting and Arbitration. So before I move ahead, I'll take a minute to introduce myself and this course. I am a lawyer based out of Delhi NCR. I have my own practice in the commercial and corporate law space. I do litigation, arbitration, and corporate advisory. Now, coming to this course, this is a 4-week course, which means that there will be 4 lectures, one lecture every Saturday, held on the 4 subsequent Saturdays starting from today. The next 3 sessions will be on the 6th, 13th, and 20th of September. If there's any change, there shouldn't be, but in case there is any change, you will be notified by the Lawchemy team well in advance. Let me just go over the basic outline of what we're trying to cover with the course here. The first lecture, that's today's lecture, will be covering the basics of contract drafting. Now, in this, we will include everything from what is a contract to what is the purpose of drafting a contract, what are the essential elements and aspects of a contract which are common to every contract that you will come across in your legal careers. And then the second lecture will cover 2 specific kinds of agreements. For this, I've selected a lease agreement and a non-disclosure agreement. The reason being, one is a very simple agreement which you will come across inevitably in your career at some point or the other. Most of you may have already seen it, which is the lease. And so the clauses are fairly simple and everyday, but this is something very important for you to understand because lease and sale are transactions we will often see in our lifetime as a lawyer. The second is a non-disclosure agreement. The reason for this being the second one was that this is slightly technical. It's more subject matter specific. And with this, we'll get a chance to drive home the point, which will be my point throughout this course, that there is no straight jacket formula for drafting a good contract. For any contract to be drafted well, for you as lawyers or law students to understand a good contract, the most important thing is for you to understand the transaction. That way, you will also see in an NDA. An NDA is never a straight jacket. It's very, very sensitive in nature, and that sensitivity comes from the nature of the transaction. So, if you are able to understand what it is that the parties are trying to do, you will be able to draft a good contract for them. Now, coming to lecture number three. Lecture three, I'm told by the Lawchemy team, arbitration agreements are in very high demand. Everyone wants to learn how to draft one. So we'll be focusing in lecture three on arbitration agreements and clauses, how they are made, why they are made, what makes a good arbitration clause versus a bad one. What are the mistakes to avoid? And we'll be covering some important aspects like what is the difference between seat and venue and how that should come across when you're drafting an arbitration contract. And lecture 4, I've left open as of now for question and answers and for doubt clarification. I will take up all your queries, if any, from within whatever we have studied, as well as anything else you might have in respect of contract drafting. If you have specific queries that you would like to bring to the class and discuss, I'll be happy to do that. Now, before I move ahead and dive into the course, I want to set a precursor here. I am assuming that you all come from a legal background in the sense that you are either studying law or will be studying law or are already qualified lawyers. So there are certain terms that we will use over and over. So I'm assuming you'll be familiar with them. Simple terms like contract, lease, um, arbitration. I assume that these are words you heard or you know that what they mean. In case there is somebody here who does not know what these words mean, I am open to helping you to understand. My only request is that when I bring up the word for the first time and you feel like मुझे नहीं पता इसका क्या मतलब है exactly जिस context में हम बात कर रहे हैं, तो I would urge कि आप उसी टाइम चैट बॉक्स में पूछ लीजिए कि क्या मतलब है. I will keep a close eye on the chat box. If anything comes up that I need, that I feel that needs to be answered right away, I will answer it right away. Otherwise, if there are any questions relating to the course that we are studying, I will take up questions at the end of the lecture. We will give it a few minutes and cover all of those aspects. Is that okay? That okay with everyone? We'll like a thumbs up, please. Okay, Himesh has given me a thumbs up. Saket has given me a thumbs up. Okay, great. Just for my understanding, is there anybody here who is not a law student or a lawyer? Then I will try to keep it even more simple and basic. Somebody who's maybe a law aspirant who's not yet joined law school or has just taken this course to basically understand or help them in the course of their business legal contract drafting. Anybody like that who has not done law? Okay, I assume the answer is no. Fantastic. So, guys, we will try to keep this course very easy and interactive. I want you to participate as much as possible, but participation doesn't mean that you will unmute yourself and speak. It means that if you have something to say, you'll say it in the comments, and otherwise, you'll raise your hand if you want to say something, and I will call out you, and then you can unmute and speak. Great. So, we will get right into it. So, the first lecture for this course is Basics of Contract Drafting. In this course, we'll be covering these headings. Basically, this is what the course is divided into for you to get a little brief capture into what all we'll be covering. First, we'll understand what a contract is, what the purpose of creating a contract is. Then we'll be going on to the essential components of a contract. So every contract has certain things which are common to it throughout. And we'll be going through all of those things. Then we'll be going through the different parts of a contract. So the main body of the contract, how it's drafted, what it says. Then we'll cover the risk allocation clauses, the boilerplate clauses, the drafting styles and best practices, things that you should do and should not do. And finally, we'll cover a clause redrafting exercise to see how many of us have actually understood what we are trying to do here today. Okay, so first and foremost, what is a contract? I would request everyone to please keep their mics on mute. Okay. So basically, a contract is an agreement between two or more parties which they will lawfully enforce. It sets out what each party promises to do or not do and create legal rights and obligations. For example, the simplest example I could think of is if you hire a photographer for any event, you agree to pay the photographer a certain fees. In return for that fees, the photographer promises to provide you a certain service. This service is, for example, you tell him कि मेरा 2 घंटे का function है. I want 200 photographs, raw images, and 50 images which are edited. Now, your part of the promise is to pay him the fees, and his part of the promise is to provide you with these 200 raw plus 50 edited images. If either side fails to deliver, the other side can seek legal remedies. So, a good contract basically covers the rights and responsibilities of both parties. And I say rights and responsibilities. So, it tells you what all you are entitled to and what all you must do to fulfill that contract, and also sets your expectations in terms of how and when you are to achieve those rights and obligations. And the purpose of a contract is not only okay because let's write it down in case there is a fight tomorrow. The idea is it minimizes misunderstandings and establishes a reference points if you do end up in a dispute. Some of the common examples of contracts you might have heard of in your everyday life are like employment contracts. If any of you has ever been in a job, you have signed an employment contract, or if you hire people, you ask them to sign employment contracts. These list out the specifications of that employment, what salary you will be paying that person, what equipment you will be giving that person for the purpose of achieving their job, what are the roles and responsibilities of that person in the job, how you can fire them and when you can fire them, when can you give them a raise? Why will you give them a raise? Bonuses, gratuity, employment provident fund. These are all the benefits that you provide to your employees. And in return for that, what are the specific profile or jobs that your employee will fulfill for you? Then there are common examples like sale agreements or lease agreements, the one we'll be talking about in the next lecture. Then there is a freelance service agreement, which has become quite popular these days, which is basically since it's back to a gig economy, a lot of us are doing freelance work now. And this freelance work is as important as any other. So freelance service agreements have become very common. Then there are more complex agreements for more detailed transactions like shareholders agreements, share subscription agreements, non-disclosure agreements, confidentiality agreements. All of these are different types of agreements. If there is any specific agreement that you want to understand how to draft, how to deal with, you can discuss that with me in the last lecture. I'll be more than happy to help you. Then the second part of what we are doing today is essentials of a valid contract. Now, this is basically the reason why I had asked if anybody here is from a non-law background. So if you have studied law in your first year, you have contract law, and in the first thing that they teach us in contract law is what are the essentials of a valid contract. Now, a valid contract under Section 10 has five features to it. The first five that you see here on the screen, which means that there is an offer by one party and an acceptance of that specific offer by the other party. A lawful consideration. Consideration can be in the form of money, can be in the form of goods, can be in the form of services. Basically, it has to be something in exchange for the promise and offer. The third thing is the capacity to contract. Now, this often sounds confusing, but it's very simple. Capacity just means that the persons entering into the contract have the legal capacity to do so, which means that they are of majority age, above the age of 18 in India, and they are of sound mind, which means that they are capable of entering into the contract and understanding what that contract means or what they are binding themselves to. Then the fourth thing, and the most important in my opinion, is free consent. Free consent basically means that the parties who are entering into the contract know what they are signing up for. There is nobody is coercing them. There is no zor zabardasti. There is no undue influence that is making them sign this contract. They are doing it willingly and are understanding what they are signing. And the fifth one is lawful object. Lawful object just means that the purpose for which you're entering into the contract is not an illegal one. The purpose is something that the law permits. So, for instance, wager is under the Contract Act specifically made illegal. So, if you're entering into a contract to wager, that contract does not constitute a contract only. So, tomorrow if you go to the court and say कि हमने wager के लिए contract किया था और इन्होंने मुझे पैसे नहीं दिए, the court will tell you, I'm sorry, your contract is not a valid contract. Therefore, you can't enforce it. Now, sixth and seventh are points which are not part of Section 10, but these are derived from the following sections of the Indian Contract Act. Point number six says law not expressly declared void. Now, when you look at the Indian Contract Act, you will see that there is a part from Section 24 to 30 which details all the kinds of contracts that are declared void. So, a contract for a specific unlawful object is void. A contract where the parties to the contract did not have the capacity to contract is declared void. A contract where the consideration is of an illegal form is void. So basically जो first five aspects of the contract हैं, अगर उनमें से कुछ भी नहीं है तो contract is declared void, and this is specified in sections 24 to 30 of the Contract Act. So point number six covers those. Point number seven is that certainty and possibility of performance. Now, this is something you may have also studied in the Specific Performance Act. Basically, this just means that the contract is possible and can be done, which means that it should not be incapable of being performed. This aspect of the contract is covered under sections 31 to 36 of the Contract Act. And with that, we will move on to the next one. Introduction to contracts. सबसे पहले we will go into an illustration to see if all of these conditions that we've seen are fulfilled in this particular contract. The illustration is Y needs a laptop. X agrees to sell a laptop to Y for 30,000 rupees. They decide that this exchange will happen on Saturday at X's house. Does this agreement fulfill the essentials of a valid contract, in your opinion? Now, class, here I need you to be a little bit interactive with me and tell me if all of the five essential essential elements that we have discussed are covered in this particular contract. First is there an offer and an acceptance? Now, if you say yes, please write in the chat box. Yes, do you think that there is an offer and an acceptance in this contract? Saket says yes. Okay. Anyone else who wants to chime in? Prerna says yes. Okay, great. Aman says yes. Okay, so I agree with you all. Yes, the answer is Y needed a laptop, and we can presume that Y went to X, who's a laptop seller, and X agreed to sell the laptop to Y. Therefore, an offer was made by Y and acceptance was made by X. Therefore, there is offer and acceptance. Now we come to the second aspect, which is lawful consideration. Consideration of 30,000 rupees is offered by X to Y for this laptop. So, do we agree that an amount of 30,000 rupees can be considered as lawful consideration? Prerna says yes. I agree with you, Prerna. Great. Saket also says yes, there is lawful consideration. So our second aspect is also fulfilled. Now, number three, capacity of the parties to contract. Now, here, on the basis of the information available to you, you don't know that the parties have the capacity to contract. But this is where, in a practical scenario, you will go in the back and check whether the capacity to contract element is fulfilled. For the purpose of this illustration, we assume that both X and Y are above the age of 18, and they both have decided to take this decision to enter into this sale agreement on their own free will. Therefore, they have the capacity to contract. Similarly, we assume that there is free consent. And finally, lawful object, buying a laptop and selling a laptop is obviously lawful. So there is no question of lawful object. Now, having seen that these conditions of section 10 are fulfilled, let's go line by line and see. Offer and acceptance. There was a clear proposal by one party and an unconditional acceptance by the other when X offered to sell the laptop and Y accepted the terms of the sale. Lawful consideration was there, rupees 30,000 was being paid in exchange for the laptop. Capacity to contract, we assume that both of them are legally competent to enter into this contract. Consent, both X and Y, we assume have willingly entered into this contract and there was no pressure, undue influence, coercion, or deception for the purpose of this agreement. Lawful object is that selling a laptop is permissible under law and there is nothing unlawful about it. Now, coming to 6 and 7, which are not technically elements of section 10, but are also more like exceptions that you need to rule out when you need to see whether a contract is lawful, is that the sale is not in any form a wager or anything illegal that the act does not permit. And certainty and possibility, of course, they have decided that the laptop has to be sold for a particular price at a particular date at a particular place of delivery, and therefore it is very clearly stated and very feasible and practical to do. Therefore, it is a certain and possible performance. So all elements of our contract are being fulfilled. The reason we are going into these basics, guys, is because when you look at contract drafting, when you draft any contract, these are exactly the things you need to see. These will become terms of that same agreement that you're making. So an understanding of the law will help you understand drafting the contract better. Okay, let's move on. Now we come to the challenging part. और अभी तक जो भी हमने किया, this was quite basic. This is what we know from law school. Now we are coming to something that life will teach you. Law school will necessarily not. The structure and essential components of a contract. So in my understanding, I've divided this into what I've learned over the years as the 5 basic parts of any contract, which are common to each and every contract. The first is the title and the date, which you see right on top of any contract. The title, the date, then come the preamble, the recitals, the definitions, if any, and interpretations of those definitions, the main body of the contract, which contains all your main terms of rights and obligations, and finally, the risk allocation and dispute clauses. Now, we'll look at each one of these separately. First, let's come to title and date. Now, the title tells the reader what is the type of the agreement. Before you even see the agreement, the title will make it clear कि okay, this is a service agreement. Service agreement का क्या मतलब है? One party is offering a service, the other party is giving a consideration for that service. That service could be anything. That service is a service made by a lawyer with their client. That service could be something like what we saw, the example about the photographer. That's a service agreement. The service can be a consultation with the chartered accountant. It can be any form of service. Now, the effective date or the date is often mentioned right on top. It says this agreement is entered into on this day between so and so and so and so. So this is your title and your date. This is nothing, no rocket science. It can be written in any way that seems logical. Now we come to the preamble. The preamble and recitals. The preamble is basically a brief opening statement that appears right after your title and date of the contract. It identifies the parties involved and specifies the type of the agreement, stating when and between who the agreement is made. So, for example, this service agreement is made on 1st September 2025 between X Private Limited, having its registered office at New Delhi, and Y and Company, having its principal place of business in Mumbai. Now we come to the recitals. Recitals are wherever you see the word whereas. In India, we have this trend where we write whereas when the recitals start. So whereas X Private Limited provides basic website development and maintenance services. Basically, recitals hote kya hai? Recitals sets the stage for the contract. It gives the reader a background of everything that has happened so far, which has led the parties to enter into this contract. So they appear immediately after the preamble and provide a background of the facts and circumstances. They explain why the parties are entering into this contract and often begin with the word whereas. While the recitals are not legally operative, when this agreement, for example, is challenged in the future, the recitals are not legally enforceable or operative part of the agreement. They play a very important role in interpreting and understanding the agreement and what led to its creation, what has happened before it. Often there are long drawn transactions where for one transaction there are tens of twenties of agreements. So in every agreement you will see a very long recital which talks about all the other 19 agreements, because you're trying to link up each one of them and make it one holistic umbrella transaction. So the recitals are very, very important. They may not be used in a court of law, but they're very important to set the stage for what's happened till now. Then we come to the definitions and interpretation. Now, definition is a clause that I always prefer to write. Not everybody does, but in my experience, it's very helpful because it's the best way for you to define the scope of the contract. So here, it's a service agreement, right? So here it's very important to explain what this service is. So in the definition clause they're talking about, services mean the web development and maintenance services described in Schedule A in this agreement. The singular includes plural and headings are for convenience only. अब आपने क्या किया यहाँ पे सर्विसेज अग्रीमेंट में आपने डिफाइन कर दिया वेब डेवलपमेंट और मेंटेनेंस सर्विसेज हैं, बट दैट्स नॉट द एक्सटेंट ऑफ द सर्विस. ऑफन अ सर्विस includes measurable, tangible outcomes. So, how much of, if I'm, for example, hiring a web developer to make a website for me, this is a service agreement. What kind of website they are making, how many pages or how many headings are there to the website, what all elements are there, are they doing my SEO also, are they not doing the SEO, is the SEO separate, what is the scope and ambit of the service, all of this has to be defined in detail. So, of course, these are sometimes very technical and unnecessary for the agreement purpose and not relevant for the lawyers as such. So we often don't include this in the body of the agreement. We include it in the form of a schedule or an appendix or an annexure, which details what all aspects of the service have to be kept in mind or what are the commercials agreed between the parties. For example, when I talked about the photographer had an agreement with me to provide me pictures of my function. But I also mentioned that there are 200 raw images, there are 50 edited images, maybe there are 10 videos. One is a complete video of the entire function, one is a video of, say, reels, that nowadays people like to have reels on their social media. All of these are part of the services of the photographer that I may not write in the body of the agreement, but I will have an appendix or an annexure where I will write all of these in detail. So that was the importance of the definition clause. The last part that you see in the definitions is the interpretation. So in this agreement, the singular includes the plural and headings are for convenience only. So why do we write headings are for convenience only?